Morning, Steve.
Good morning, my lords. Here we go. My lords, may we go arrow-like to the grounds of appeal. As before, I'd be grateful if you could have as accessibly as possible the judgment, which I'll be referring to constantly. We start with ground 1A, which is in two parts. It's the first part of 1A, and this is the failure to address the English defendants separately to and before Dyson Malaysia's application. We address this in paragraphs 7 to 9 at page 32 of our skeleton core bundle. My lords, in a nutshell, we submit that the judge correctly directed himself on the law, and he properly applied the holistic mixed case approach from paragraph 68 of Vedanta and the stage 1 Spiliada test. There is no error of law. If we just look at the judgment, you've already been taken to it. Paragraph 27, page 83 of the core bundle, and following, 27 and 28, he identifies the different tests for service in and service out types of case. He correctly identifies in 28 that it's necessary to demonstrate that there's another appropriate forum which is available, which is clearly and distinctly more appropriate. And then he pulls it together in paragraph 30. The instant case involves a mix of both service in and service out cases. In these circumstances, quoting Lord Briggs in Vedanta, the court is looking for a single jurisdiction in which the claims against all the defendants may most suitably be tried. We respectfully submit that is the right question. He couples that in paragraph 35 on page 84 of the bundle by identifying the stage 1 question, referring to Lord Gough in Spiliada. You're looking for the forum with which the action had the most real and substantial connection, and then he identifies certain factors identified by Lord Briggs, which are both matters of practical convenience and other matters such as system of law, which will be applied to decide the issues, the place where the wrongful act or omission occurred, and the place where the harm occurred. He then pulls that together, having identified certain key factors, and you've been taken to these. It's true that he refers at paragraph 84 to a question of convenience in relation to the witnesses, but he's not allowing that to usurp the overarching test he's applying. He's perfectly properly at that stage looking at connecting factors, and when you're looking at connecting factors, questions of convenience, for want of a better word, are perfectly relevant. Obviously, the overarching test is, as the Master of Rolls pointed out yesterday, which is the appropriate forum, having regard to what Lord Gough said in Spiliada. But then he pulls it together in paragraph 122, and there's no question we submit that he applies the law correctly when he says in the first sentence, taking all of these factors into account, my conclusion at the end of stage 1 is that England is not the natural or appropriate forum, and that Malaysia is another available forum which is clearly and distinctly more appropriate. And it's worth also noting paragraph 123, where he deals with Mr. Hermer's suggestion of severance of the claims against D1 and D2. So one can see that as a matter of fact, his conclusions were also referable solely to D1 and D2, as he says halfway through paragraph 23, the factors that have driven the conclusion set out in the previous paragraphs apply to the claim against D1 and D2. And then taking into account the counter-arguments, he says, whilst it is correct that the alleged actions or omissions took place in England, any claim against them is contingent on making out that harm was caused to the claimants in Malaysia. Further, the governing law is that of Malaysia. So, my Lord, before I make my submissions, could I just refer you to two cases, going first to Vedanta very briefly. You've been taken to it. It's in the Authorities Bundle, Volume 2, Divider 23. And could we start at page 846 of the bundle, which is paragraph 52 of the Authorities, so I don't have to come back to it later. But I just wanted to draw your attention at page 846 of the bundle to paragraphs 52 to 55. This is relevant to centre of gravity because, as you can see in Vedanta, as indeed in Connolly, in Unilever and Luby, which are parent company alleged duty cases, exactly the same essential arguments are being relied on. Or I would submit this is an even weaker case because we're dealing with a supply chain. As you can see from paragraph 55 on page 847, the essence of the claimant's case against Vedanta is that it exercised a sufficiently high level of supervision and control over the activities of the mine with sufficient knowledge of the propensity of those activities to cause toxic escapes. In a lengthy particulars of claim, the claimants make copious reference, including quoting highlights to material published by Vedanta, in which it's asserted its responsibility for the establishment of the appropriate group-wide environmental control and sustainability standards for their implementation throughout the group by training, and so on and so on. Those are the arguments that have been made in these parent company cases, and the court had no difficulty at first instance, the Court of Appeal and the Supreme Court, in confirming that the real and substantial connection of the case was nonetheless, in this instance, with Zambia. This is a different case, and I'll come to the arguments in relation to centre of gravity, but I would suggest that it's an even stronger case in favour, as it were, of Malaysia. Then, returning to the instant ground of appeal, the relevant paragraph is paragraph 68, and you can see the extent to which there Lord Briggs is drawing on Lord Gough in Spiliada when he says the concept behind the phrases the forum and the proper place is that the court is looking for a single jurisdiction in which the claims against all the defendants may most suitably be tried. And before that, he's referred, as you can see from the earlier section of paragraph 68, to the original formulation of the concept by Lord Gough. You've been taken to other paragraphs. Then, if you move forward to paragraph 85, you'll see they re-exercise the discretion having regard to the error in relation to the trump card point, and refers to the fact that Zambia was overwhelmingly the proper place for the claim to be tried. It's just worth noting that they look at them broadly in the round and say, in fact, almost at the end of paragraph 85, before moving to the sub-paragraphs, in fact, almost all the connecting factors with Zambia identified by the judge are equally applicable to the case as a whole, i.e. as against KCN and Vedanta, in summary, and then they go through the various factors. And then paragraph 87 on page 855 starts with the sentence, in conclusion, it is sensible to stand back and look at the matter in the round. That is, in my submission, exactly what the judge did here. It's also worth noting, and I don't propose to take the court to it, but it's in the supplemental authorities bundle, a matter of interest only I know to this court would be that Mr. Justice Butcher recently, in the case of Mercedes-Benz Group and Continental TEVS UK Limited, that's the supplementary authorities for your reference, tab 4, page 89. It's a post-Brexit mixed case. He referred to Vedanta, paragraph 68, and there, in that case, looked at the connecting factors in the round with the agreement of the parties. I don't propose to go to a GAD. It's a different set of facts. Mrs. Justice Cockrell, in our submission, was certainly not laying down a rule of law. And on closer analysis, it's clear that stage 1 was agreed. There was an interesting situation under stage 2, in which one of the defendants was arguing, and that argument was dealt with for obvious reasons sequentially, that if Saudi Arabia was not an appropriate forum, then Jordan was. But I respectfully submit the court can't derive any great assistance from that case. So these are my submissions in relation to this ground, as I've said, the judge properly applied the correct test and in accordance with both Vedanta and Stage 1 Spiliada. In any event, it's clear from the judgment at paragraph 123, which I've taken you to, that the judge did consider the issue of appropriate forum for the claims against English defendants separately and said he would have reached the same conclusion. It's not necessary, we respectfully submit, as a matter of law, to adopt a mechanistic sequential approach as proposed by the claimants, and it potentially gives rise to difficulties and complications of the type that the court was exploring yesterday. It is in the interests of justice, therefore, to pose Lord Briggs's question and look at connecting factors in the round, having regard to the case as a whole. Cases of this type do not normally turn on the burden of proof, and this one certainly didn't, and the judge was clearly satisfied, as you've seen from his judgment, that Malaysia was clearly and distinctly more appropriate. It's not arguable if it was a relevant point that separate and sequential approach would have made any difference to his conclusions. My Lord, the second part of ground A is the argument that the judge failed to take into account a key connecting factor, namely domicile. And it said he didn't mention the fact and importance of domicile in his conclusions at 122 and 123, and it's further said that the strength of the connection is reinforced by the fact that the English defendants employ thousands of employees in England, including individuals with responsibility and oversight and coordination of Dyson's worldwide supply chain. So it's sort of put on two bases, but essentially, as I understand it, it's a proposition of law that he ought to have given greater weight to this particular factor. It said he relied too much on practical factors. Just dealing with that latter point, he didn't just rely on practical factors, he also took into account Malaysian law, irreconcilable judgments, and centre of gravity, which is perfectly reasonable and properly evidenced the weighing exercise he undertook. Just going then to the judgment, we've looked at paragraphs 27 to 35. It's worth also noting paragraph 37, which you've been referred to, which is a reference to Lord Briggs again in Vedanta, and the fact that even in a pre-Brexit case, where the claimant has made a deliberate choice to sue in this forum and has thereby engendered the risk of irreconcilable judgments, it would offend the common sense of all reasonable observers to think the proper case for this litigation to be conducted was England. So even in a pre-Brexit case, domicile was not treated as a trump card where there was an undertaking to submit to the jurisdiction of the other appropriate forum. He then, we know from paragraph 52, because he refers to it expressly, for the avoidance of any doubt, that he took into account the submission that Mr. Hermer made at page 90 of the judgment. Mr. Hermer sought to impress on me that from an access to justice perspective, where the English court was seized of jurisdiction and knows that a fair trial is possible here, it should not lightly relinquish that jurisdiction. And he referred again to the point at paragraph 70, little 1 of his judgment, and as a general submission, to the avoidance of any doubt, at paragraph 82, he underlined throughout that he carefully considered all the written and oral submissions. And there is, as a general point further, no criticism of his recitation of the parties' submissions. So, my lords...
I'm sorry, it's my fault. In which specific paragraph do you say he shows he was taking account of domicile as itself a relevant or important fact?
I pointed to 52. I'm also going to...
Well, that's about access to justice, isn't it?
Yes. I apologise. He did not take it into account as a key factor. It was referred to him, and in my submission he was right, and it was reasonable of him not to do so. So I was just seeking to establish that he did take it into account.
Yes, and I wasn't quite sure where of the paragraphs you'd taken us to. I could see that.
Well, paragraph 82, he underlined he'd carefully considered all the evidence presented to him along with the written and oral submissions. And the submission was clearly made, and he referred to it at paragraph 70, Roman numeral 1.
Okay, thank you.
So in our submission, there was no misdirection of law. The judge correctly directed himself as to the proper approach and the law as to connecting factors. He correctly set out the law in relation to stage 1, as I've shown you. He plainly did have regard to the significance of the domicile and place of business of D1 and D2, including the fact they were sued as of right. As I've shown you, the submission was made to him and he took it into account. The question, therefore, is as to the weight that should be accorded to the domicile of D1 and D2 and the fact that they were served as of right. In our submission, the judge was right not to treat that as a key or decisive factor. In any event, weight is a matter for him, but he was clearly right because this is not purely a service-in case. D3 was served out, and therefore D3's domicile has to be taken into account. As you were shown yesterday by reference to Spiliada, page 23 of the Authorities Bundle, Divider 6, letter E, the court pays proper regard to the fact that jurisdiction has been founded as of right by reference to the clearly and distinctly test. But that burden switches in service out cases, so establishing that the appropriate forum is clearly and distinctly the foreign forum, or the alternative forum, the burden is the same both in a service out and a service in case, so they effectively cancel each other out. What the claimants are seeking to do here in our submission, in a mixed service out case, is to nonetheless, quite wrongly, claim some special status or reliance on the domicile of the anchor defendant, ignoring the service out test, and therefore by the back door, or possibly even by the front door, reintroducing Owusu in Article 4 of the Brussels recast. And essentially, when you look at their skeleton at paragraph 21, reading between the lines, they don't say it overtly, but they refer to Owusu, they refer to the Brussels recast, they make arguments by reference to the juridical basis underpinning the question of domicile under Brussels recast, all of which we respectfully submit is now irrelevant post-Brexit. One's simply applying the Spiliada test, and one's applying it to a mixed case. All the same factors that are relevant to D1 and 2 are just as relevant to D3. And the judge didn't expressly refer to the domicile as D3 as a key connecting factor, but again, in my respectful submission, it's clear that he would have had regard, and there's no reason to doubt that he did have regard to both. So in my submission, there was therefore, clearly we submit no error of law in approach, and indeed we would submit the judge carried out the balancing exercise appropriately too. So, my lords, for those reasons, we respectfully submit that there is no error of law demonstrated in relation to ground 1A in its two parts.
Can I just ask you about cancelling out? I understand in principle your submission, but I think it's said against you that you have to look at each individual case to see whether they cancel out where you've got a mixed case. And there is invoked against you a principle, which I'd be interested to know whether you agree with as a matter of principle, that not all defendants are the same, and they can be divided sometimes into those who are protagonists and those who are of less importance, with metaphors of tails and dogs. And then it is said on the basis of that, this is a case in which the English defendants are much the most important defendants, and the Malaysian defendant is very much ancillary and sued as a necessary proper party, so that the factors wouldn't cancel each other out, although you would have to take account of the fact that on the submission as it's put against you, on the one side you've got what would be described as the primary defendants with their domicile here, and you give weight to that, and then you weigh against that a rather lesser factor, namely the domicile of the Malaysian defendant, which is lesser because they are the tail, to use the dog metaphor, or really an ancillary defendant. I may not have captured the argument exactly, but I think that's the gist of a point that's taken against you.
Yes. There have been cases in which the courts, I think you were taken to one, and BTB I think might be an example, in which the courts have considered whether one or more of a number of defendants in a case where there are a number is a more important protagonist than another. Insofar as that is a relevant factor, in my submission that was properly dealt with by the judge when considering questions of centre of gravity and the true focus of the litigation. Dealing further with your lordship's point.
But you accept it as an appropriate inquiry?
It's an appropriate inquiry. Yeah. And in my submission it's one that the judge clearly did embark on. But insofar as when he was considering that what is described under this ground, and is, I think, on a proper interpretation of this ground, the pure question of domicile, it's put on a narrower basis than that. It is in effect said that domicile should have been treated not as a trump card, but should have been a key factor for D1 and D2 because of the domicile. And in my submission, that is the equal and opposite point can be made just as forcefully in respect of D3. I could make exactly the same point about D3. And following on from your lordship's point, he did at paragraph 85 actually, as a key factor, take into account where the various witnesses, he treated it as a neutral factor, but you'll recall that he did look at the witnesses of D1 and D2 and where they were when he was going through that issue at paragraph 85 of his judgment.
Well, that's practical convenience, which is a slightly different point from the one we're on at the moment, which is importance of domicile.
Yes, well, in my submission there's the pure importance of domicile point, and you have my submissions on that. Your lordship, if I may interpolate, is adding to it, well, there may be a further point that in a particular case, and this could arguably be one, that you take into account the fact that the defendant in question is not just domiciled, but carries on its business to a greater or lesser extent in the instant form.
No, I think the point that's put against you, it's not my point, it's what I understand Ms. Kinsler to be saying, is that the answer to your submission to us, which is they are just equal and opposites and cancel each other out, is that may be so in some cases, but isn't so in all cases. And if you look at their relevant importance to the claim, they don't in this case cancel out. Because, to perhaps paraphrase, the most important defendants are the English defendants, and the Malaysian defendant has been added as a bit player, and only because you pointed the finger at them.
Well,
that I think is the argument.
Yes,
I just wanted to know whether you wanted to say anything about that on the,
yeah, I mean, my
on the
response
facts, as it were.
my response to that is, and I've already endeavoured to show you that is simply not accurate. If you have a look at the pleading and the issues arising in the case, Dyson Malaysia could not possibly be described as a bit part player who's simply been added on. In our submission, Dyson Malaysia's role, as you can see from the pleading, is manifestly of central importance to this case, and the judge was right in his assessment of its role when he looked at centre of gravity. I'm accepting in principle that if you had a bit part player, then that could be a relevant factor at this stage. I hope not in any way undermining my submission in relation to the law of domicile, but this, in short, the answer to the point is this is not a bit part player case.
Thank you.
And you don't have to take it from me. You can take it from Mr. Holland, who, in his statement, his first statement, which is, we need to turn it up, it's a core supplementary bundle, tab 2, page 30, paragraph 70, where he says, I draw the court's attention to the various statements which Baker and Mackenzie have made, which stress the central role that Dyson Malaysia played at material times, and then he goes on and makes the point about Dyson Malaysia having been responsible for setting standards, auditing, training, supervising, and of course being the contracting party.
I think the case, as it's put against you, is the allegations were made against the UK defendants, which then said, oh no, you've got that wrong, we're not in control, it's D3 in Malaysia, and they adopted that as an alternative, further an alternative case. So it may not be that Mr. Holland there is as it were, saying on his own account, that's the position he's saying, well, that's what the Dyson group has said.
Well, that's what they've pleaded,
Yeah.
and they have to plead it because they have to demonstrate under the gateway that they have a reasonably arguable case against Dyson Malaysia. And indeed, on the facts of this particular case, again, you can see there's no dispute that Dyson Malaysia is the only company in the Dyson group that actually contracts with Atterjay. So there's nothing manufactured about it. And all the court is expected to do and can do in these jurisdiction applications, as I know the court knows well, is look at the pleading and decide the issues by reference to what is alleged in order to determine the question of forum. There's no challenge on this particular jurisdiction hearing to whether there's a real issue, which there is, of course, in some.
Well, can we look at the reality? The reality is that Dyson is a very, very big English organisation which sources goods around the world, and Malaysia is one of the places where it sources goods. And what is said is that it has, as a big English multinational corporation, a code of conduct which it has failed in this case to give effect to. Why is that not the reality, rather than looking at some local company that is created in order to help manufacture goods in the particular country in question? And we also see, of course, that these are migrant workers who are not Malaysian at all. And in fact, most of them can't even go there. You know, why doesn't that lead to the conclusion that domicile is important and that centre of gravity is not really completely Malaysia? Of course, there's a great Malaysian connection because it all took place there. But you can't just look at the facts without looking at the reality. And some of the submissions that you're making seem to me to be, so far from standing back, standing sort of in Kuala Lumpur and saying, how does this look from Kuala Lumpur? Yes, of course, it all took place here in Kuala Lumpur, so therefore it's Malaysian. But if you stand back, you've got this multinational corporation, which is a very big company based here, and the allegation is that it's the rules that it failed to impose on one of its satellites. Question is that, what does that mean?
Well, I've shown you the way the courts have approached exactly the same question in the parent company cases.
But are the parent company cases really comparable?
I would argue that they are, taking your lordship's line of argument, on paper they're stronger, because it is at least a parent company in the same group. We are dealing
They're different, aren't they? Because the case is different.
Well, every case I accept is different, but the same arguments are essentially being made in order to allege that there is a duty of care owed by the parent company. In this case, we don't have a satellite company. We have a wholly independent Malaysian company. This wasn't set up by Dyson. They are Atajay is a very substantial...
Is there evidence that all the profits of the Malaysian company are kept in Malaysia for the Malaysian company?
Well,
is that what you're saying? It's a really freestanding corporation.
Yes, it is.
That all the profits are kept in Malaysia. Is there evidence of that?
Sorry, are you talking about Dyson Malaysia?
Yeah, I mean, you're saying, well, it's all about Dyson Malaysia, the business is in Malaysia, it's all done by Malaysia. What, as I understand, is said against you is that the centre of gravity of Dyson is in, I can't remember the town in England, but in England. Malmesbury.
Well, there's... well, my lords...
I mean, what I'm putting to you, Mr. Gibson, and I want you to have the opportunity to deal with it, is that we have to be real about this case and not pretend, not to get into the weeds of it without understanding that this case is about Dyson and what Dyson did and how Dyson traded, and that is anyway one factor in the stage 1 Spiliada exercise.
I do not dispute that it is one factor. There is an aspect of this case, of course, I accept, that will address at trial the role of Dyson, the UK companies. Of course, those are allegations that are made. But the binary question for this court, which is and in my respectful submission I'm being entirely real, is where is the centre of gravity of this case? And one only has to look at the pleading in my submission to see that the entire case against the English defendants depends upon the claimants establishing the various breaches of contract or acts and omissions on the part of Atajay and the police. That is how it has been put. And that, of course, is one of the reasons why it is in Dyson's legitimate interest, and this is relevant to the undertakings that I'll come to, for this case to be in Malaysia, because that is the only jurisdiction where it can have all the parties before the court.
I thought the case was a negligence case and an unjust enrichment case.
And a joint tortfeasorship case. So it's also said that the Dyson companies have procured the activities and assisted in the activities of Atajay and the police in such a way that they are potentially joint tortfeasors. But everything starts in Malaysia. Everything happened in Malaysia. The fact that some policies may have been promulgated in England is a matter of record. And it is the case, and the claimant is alleging that they are saying, well, you have these policies, you have these codes of conduct, and you are not sufficiently ensuring that they are enforced. Well, the starting point of the trial in relation to that question is, were they in fact adequately enforced by Atajay, and or were the police acting as alleged? And the second key question involved in that is what was happening on the ground in Malaysia through Dyson Malaysia, because we know they were the Malaysian company responsible for training, auditing, overseeing and setting the local standards.
You see, a question that comes to my mind, I take all those points, Mr. Gibson, and I think I understand them. Isn't it more convenient for Dyson to be sued here? It's an English corporation, it's got overshore aspects, but isn't that really the more convenient course? So one asks the question as an inquiring judge, I
yes.
don't mean inquisitorial judge, but somebody who's got an inquiring mind, why on earth would you make this application to try and kick it out of your home jurisdiction where we have fair judges and everybody knows how to deal with them and the other side is keen apparently to litigate here? Why on earth would you be asking to take it somewhere else where it would be at least more difficult for you or anybody else to litigate, because we know the other side have all the difficulties we've seen? And that's what I just ask as an ordinary observer.
Yes.
Why? Why do you want to have it out somewhere else? There must be some reason, and it sort of sounds like a reason of putting obstacles in the path of the claimant.
No, my lord, absolutely not. The question for the court under stage 1, as we've been discussing, is where can the case most suitably be tried in the interest of justice and the interest of the parties. You look at that question by reference to the connecting factors, and we've looked at the connecting factors, and in our submission they point overwhelmingly to Malaysia. Why is it in the Dyson, English Dyson company's interest, legitimate interest, I would argue, for the case to be in Malaysia? Very simple. There's an excellent reason, because that is where all the key parties and where the primary tortfeasors will be before the court. Atta will be before the court, and the police, if necessary, will be before the court. The police can't be before the court in this country because of acts of state immunity, which they haven't waived, and there's no likelihood they will. And as there's evidence about this, and it's in Richmond 1, and you may have seen it, it's paragraph 30 of Richmond 1, and I'll get the reference, where she sets out the various contracts that are relied on as between Dyson Malaysia, the framework agreements as they're called, and I showed you them in the pleading, and Atta J. Those contracts have indemnity clauses benefiting Dyson Malaysia, which obviously Dyson Malaysia would wish to rely on. But the problem is they also have jurisdiction clauses in favour of Malaysia. So, and the judge drew attention to this when he was looking at the question of irreconcilable judgments. The problem for the Dyson companies is that they would not, or may not, be able to rely on those indemnities in this jurisdiction.
Does that mean more than that any contribution proceedings would have to be pursued in Malaysia? It means they couldn't all be in one place here.
They couldn't all be in one place here.
So they could be separate and after the event in Malaysia.
You then have to have a separate hearing, which we're trying to avoid, because we're trying to.
No, I'm just trying to work out.
Yes, but you could on paper.
Yeah, but it would be separate hearings.
They'd be a separate. You'd have to have a separate trial with the real risk of irreconcilable findings.
But I thought the judge treated the risk of irreconcilable judgments with respect to ATA/J as fanciful rather than real. 117. I didn't understand it to be a response.
Well, that's because he found that if Atta J did not submit to the jurisdiction of this court, it would be possible to get a judgment against them, which would be enforceable in Malaysia. Yeah. But he didn't make findings in relation to, or rely in relation to the point that I'm using, or relying on to address my Lord's point, where my Lord just says to me, as a judge, why is it in your interest to be in Malaysia? And we explained that, leaving aside the stage 1 points, which are reasonable for a defendant to take advantage of. It is in our interest to be in Malaysia because we will there be able to have all of the primary tortfeasors present without any doubt, easy access to their documents and witnesses.
But it's in the interest of all the parties, Mr. Gibson, and the ends of justice. Listening, I know we can't confuse stage 1 and stage 2, but listening to stage 2 arguments yesterday, one thought, well, is this interest in the interest of all the parties, including the claimants, and the ends of justice, including the claimants, to go to Malaysia? And that's what I'm putting to you, because I want you to have a really fair opportunity to say why Dyson chooses to uproot this case to Malaysia.
Well, in my submission, it's not being uprooted in that sense. Dyson is applying the law, the evaluative exercise the court has encouraged you under Spiliada. And Spiliada is an evaluative exercise. I can't rely on anything other than the proper factors under Spiliada. And that is what we are seeking to do and have done. And
but sometimes, I mean, just to make my point clear, sometimes commercial organisations, even though they have an opportunity to make an application under a principle like that in Spiliada, would choose, seeing that the interest of justice might really favour leaving this case where it is, might choose to say, well, we see that we don't have to exercise that right, even though we have the right to apply, because of all the difficulties for the justice that might be accorded to the claimants if they had to go there. And that would be a responsible kind of attitude that some corporations would take. And I'm just asking why Dyson seeks to stand on its rights and say, let's drill down into Spiliada and see that the centre of gravity is of various parts of this case is in Malaysia, and therefore we should uproot it. Because you don't have to apply for a forum non conveniens stay. You could just have defended the case.
Well, my lord, there are obviously two stages. One is stage one and the other is stage two, and I'll address you on access to justice. But for the avoidance of any doubt, the judge was rightly satisfied in our submission, and I'll show you why when you look at the evidence we would submit in a fair way, that these claimants can undoubtedly get access to justice in Malaysia. Indeed, this is my submission, it's insulting to suggest they can't, when one actually looks at the evidence and the nature of the Malaysian justice system and their lawyers.
Of course they can. Nobody's suggesting the Malaysian justice system is other than excellent. It's not.
Well, and they can get the lawyers to do it.
With money.
There are a large number of lawyers, and they have CFAs which are and so on. So
we trespass on stage two.
That stage two. We come back to your lordship's question. Well, what's the real reason? And the real reason is that in Malaysia, Dyson is able to have all of the parties before the court, and it can take advantage of its contractual indemnities. And in our submission, in a case which is focused on what Atta J, the Malaysian company, did, in the way that this is, it's perfectly reasonable, leaving aside whether it's legally correct, it's also totally reasonable for Dyson as a commercial group to say that when you drill, without even drilling down, when you just look at the pleading and the way the case is put, it's so clearly contingent upon everything that happened in Malaysia and on the treatment at a factory in Malaysia and accommodation in Malaysia, that should be determined by Malaysian judges in Malaysia.
Good. Okay, thank you.
Sorry, just on a small point on that. Have I understood correctly that all the relevant contracts had Malaysian law, effectively, clauses, save towards a later stage when Dyson Singapore had the relevant contract, and that had a Singapore arbitration clause, is
yes,
that
right? Correct.
So insofar as that governed, you would have fragmentation. You wouldn't be able to manage it all.
It only governs from 2020, and these claims are up to 2020. So, and the termination took place in 2023. Yes. So it's a tail end, and
although perhaps quite an important tail end, because it's at a stage after Mr. Hall has been allegedly bringing matters to the attention of the group.
If we just go to Richmond.
I've forgotten when he first is said to become involved. Is it late 2019? Something like that.
If we just go to Richmond 1. It's paragraph, page 206 of core supplementary. Paragraph 30.3.
Yes.
As for the indemnity claims, I set out at Schedule 3 a schedule of the contracts that are likely to be relevant to any dispute. She then goes through each of them and explains why Malaysian law is the relevant law and the Malaysian court has exclusive jurisdiction to determine any indemnity.
Yeah.
She deals with the sixth contract at paragraph 30.3.4. Is governed by Malaysian law and provides for disputes to be resolved by way of an arbitration seated in Singapore. This contract was entered into October 2020, post-dating the majority of the claimant's periods of employment with ATA and JABCO. The extent to which it might be relevant, if at all, in respect of any contribution claim in respect of the claimant's claims would need to be determined following further disclosure. Would in any case be open to ATA and JABCO and Dyson Singapore to agree to waive the arbitration clause and to elect to fold any claims arising in respect of this contract with other contribution claims subject to the jurisdiction of the Malaysian courts in order to avoid a multiplicity of proceedings and potentially inconsistent outcomes.
Yes.
And ATA-J, as you can imagine in correspondence, are contesting that these claims should be heard in Malaysia. That's as far as we've been able to elicit from them at this stage. Can I just show you the contracts are at page 2, or the key clauses in the contracts are at page 263 and following.
Yes, I'm not sure that what Mr. Richmond said about them has been challenged, has it?
No. So, my lords, we've moved, and I think that the discussion has also moved to ground 1B, which is failing to have any proper regard to other key connecting factors with England by concluding that the centre of gravity of the case is with Malaysia. We address this at paragraphs 12 to 15 of our skeleton. I've already shown you that the judge correctly identified, or at least there's no challenge to his identification of the issues, and his reasoning in relation to this, relevant to this ground, starts at 102, where he says on page 103 of the core binding, the centre of gravity of this case is plainly Malaysia, and this is a strong factor pointing towards Malaysia as being the proper forum. He makes the point, which in my submission is correct and is not challenged, that the claims against the Dyson defendants are contingent on whether the underlying mistreatment, which is alleged to have taken place from 2011 to 2022, and or by the Malaysian police actually occurred. If that did not occur, the claims would fail, irrespective of whether in principle they could be held liable for what took place within the supply chain. In other words, even though D1 and D2 are situated in England, the policies which they promulgate and alleged to have been contravened applied to activities that took place in Malaysia and would have been based on information arising from Malaysia via D3, which had the direct contractual relationship with ATA-J and primary responsibility for policing ATA-J's treatment of its employees. The Dyson defendants have not admitted this treatment, and I cannot assume they will. That sentence was dealing with the submission that in some way the court ought to proceed quite wrongly on the basis that the mistreatment would be admitted or largely admitted, which it plainly would not. But then he says, in my submission, entirely reasonably and correctly, the allegations as to the underlying mistreatment are fundamental to the claimant's claim and are likely to take up a considerable portion of the hearing on liability. In the circumstances, I cannot accept Mr. Herman's submission that the main focus of the trial will in reality be concerned with D1 and D2 and the Dyson defendants' policies, activities and arguments about their liability. So he plainly takes into account and applies his mind to the contrary arguments that are being made and were being made about the focus being England, and in my submission evaluated that and reasonably concluded and rightly concluded that it would not be. And if one just does stand back, there's no misdirection of law here, so it is, we would submit, an impermissible attempt to invite this court to interfere with an evaluation exercise. But even without going again to the particulars of claim, one has a situation in which the primary wrongdoers, certainly the first instance wrongdoers, are employees of ATA-J, JABCO, and the police. The claims are based on alleged mistreatment by those employees and by the Malaysian police that took place during the course of the claimant's employment in Malaysia. The place of wrongdoing is Malaysia. The claims are contingent in the sense that the judge explained. The key party, we would say the central party in the defendant group, is Dyson Malaysia. It had the contracts, it had the roles that you see are alleged against it. Insofar as there's a generic case against D1 and D2, as you've seen, that's heavily reliant on existing documents and policies and knowledge based in the public domain. But the alleged knowledge is of events in Malaysia. The particulars of negligence are directed at failing to prevent wrongs done in Malaysia by the Malaysian ATA-J employees and the police. The intentional torts all happened in Malaysia. None of the actors has any connection with England. The joint liability claim is brought by placing reliance on the actions of ATA-J. The alleged unjust enrichment, although I accept in part, is linked to England for the reasons that my Lord identified yesterday, but substantially took place in Malaysia, and I've taken you to the plea in relation to that. The loss and damage occurred in Malaysia, or insofar as personal injury effects continued, they happened in Nepal, Bangladesh, United Arab Emirates and Malaysia in the case of 5 of the claimants, but not England. And so to the extent that the claimants were victims of policies and standards alleged to have been created in the UK, the place that those policies and standards were allegedly implemented and enforced inappropriately or inadequately was Malaysia. And serious allegations, as you've seen from the pleading and will have seen, are made against ATA-J employees for their role in what happened, and indeed even their role in what happened in the police station. So we submit the judge was plainly right to say the evidence will focus on what the claimants say about their conditions, what the Dyson Malaysia's witnesses and documents say about those matters. The contracts between Dyson Malaysia and ATA-J are crucial, how the policies were enforced on the ground, and what the net effect was, because, my lords, it's important in my submission to have at the forefront of one's mind that, leaving aside the torts of assault and intimidation and so on, the claim in negligence is for economic losses. And those economic losses are alleged to have occurred because ATA-J, as you've seen from the schedules, deducted wages or failed to take into account overtime and so on. Those are not peripheral matters. They are absolutely central and would have to be established before one could then embark on the legal analysis. And of course, as my Lord, the Master of the Rolls, points out to me, in all this, the legal issues are of considerable importance and novelty. And I, of course, accept that, but they are very fact-specific. That is why the defendants came unstuck in Vedanta and in Okparbi, were attempts to allege that there was no duty of care, and essentially, as you know, the Supreme Court said, well, questions of control, questions of knowledge and so on, and what may or may not have happened on the ground in Zambia, in Nigeria, or in Malaysia, in this instance, are all very fact-specific. So you can't possibly demonstrate at a summary judgment level that the claim is not arguable. But this case is, we would submit, a fortiori, a very fact-specific case. And what may or may not have been promulgated in England is going to be of very little relevance, other than that they were promulgated, when compared to the central questions of what actually happened, or did not happen, which should have happened, it said, in Malaysia.
Well, the promulgation is relevant to duty, isn't it? If one's looking at Vedanta roots
It's,
1, 2, 3, 4 as they've been
yes.
labelled. One has to look at the practical extent of the control, to put it loosely.
Yes.
And you may say there may not be any dispute about the promulgation of the particular documents that have so far been identified, but I rather doubt you're going to concede that there's a sufficient case of control to say that duty won't be an issue in the first place.
Yes. And
that is an English question, isn't it?
There's an English question as to whether the policies were promulgated, but in fact, when one stands back and looks at the nature of the pleading and what is said, there can't be a great deal of dispute that these policies which have been pleaded were promulgated. There'll be questions as to when and by whom exactly, but even assuming the English defendants at a relevant time promulgated a policy, there it is. There is a policy. What will matter is what happened on the ground and how involved the relevant parties were on the ground. I appreciate Lord Briggs put it broadly that you could owe a duty in circumstances where you hold yourself out, and that would be a pure question of law. But
that's English-centric, isn't it? It's not only what they happen to do in Malaysia in terms of implementation of policies or exercising control, it's what they did in Wiltshire.
My lord,
putting it crudely.
There is an English element to this case. I've never suggested otherwise. There is an English element. But the real and substantial connection, we respectfully submit, is with Malaysia.
I understand.
And when you stand back and look at the policy arguments, in my submission, yes, there will be English-based questions as to what may have happened in Malmesbury in 2011 when somebody promulgated a policy. But the policy speaks for itself, and the claimants have pleaded the policies and the codes. And their cases, you put these policies and codes out there, and a separate company, not part of the Dyson Group, despite your efforts, or whatever you say Dyson Malaysia did not comply with them. And as a result, two things they say happen. In law, query in Malaysian law, but certainly the argument under Malaysian law is that puts you in a position of proximity with the employees of Atajay. But even when one's considering questions such as proximity of the employees, one can immediately see there'll have to be a detailed factual inquiry as to the way in which those policies were actually implemented and enforced on the ground. Because how else do you make out proximity?
Well, is part of the case to do with Mr. Hall's communications, alerting the UK companies to what was allegedly going on, and their response to that? Now, you may say, well, those communications won't be disputed. The question then is whether the claimants, well, it'll have to be examined whether the claimants are right in inviting the inference that nothing was being done or nothing adequate was being done in response to those notifications. And
there'll be an argument over what was being done. Again, I accept there is an issue. One issue in the case is what different entities within the Dyson Group did in response to the Hall allegations.
from whenever it is in 2019.
It's not till 2019, and this case starts in 2011. And B, you'll still be looking at the allegations by reference to what actually was happening in Malaysia and what was being done about them in Malaysia. So yes, there's one issue. It's relied on. I mean, this is the other. This Hayne puts it in the context of the causes of action, because it's relied on as a knowledge argument. It's not. It may be relied on in order to assist to prove that what mistreatment there was, but it's also said, well, Dyson Group. One of the reasons you knew that these conditions were unacceptable was because you were told by Hall, and that is one of the allegations which will have to be addressed, but it goes to knowledge. But the key allegations in relation to knowledge are you were carrying out audits, and that was being done by Dyson Malaysia. So, forgive forgive me for repeating it, I accept one can find aspects of this case.
Well, you say it was done by Dyson Malaysia. I think, wasn't the evidence that it was done by an independent company?
Dyson Malaysia had overall control of the process. There was evidence that there was an audit done by an independent company, yes.
And it will be a matter of evidence as to whether that was then just sent straight off to England, or whether Dyson Malaysia really had anything to do with taking it into account.
Well,
Mr. Limbu, don't get me wrong, I entirely understand your submissions on,
yes.
on a lot of the factors being Malaysian-centric. I'm only offering a little pushback on one or two of them.
Yes, no, I understand.
Well, I think we're on 1B, or we were on 1B. Are we moving on to 1C?
Yes, my lords, may I just... Yes. This is the ground in which the claimants say the judge erred as to the weight to be accorded to the fact that Malaysian law applied, because he wrongly took into account public policy and failed to reflect the well-established approach of the English court.
Well, you say, it's a very simple point, this, you say he didn't.
No, he applied Lord Mance in VTB.
Well, I mean, you say, I think, if you remind me of the paragraph, where is it in the judgment?
Where he refers to, paragraph 39 is where he refers to Lord Mance.
Yeah.
And 114 is the... Oh, hang on.
114?
No, it's 1122, which is the
That's the...
judgment, the passage in the judgment was criticised. Good policy reasons.
Could your lordship just give that judgment reference?
That's
again?
122 on page 107, I think.
Sorry,
It's criticised.
So
So
good
this is
policy reasons for letting Malaysian judges consider the novel points of law.
Yes. Well, he's drawing together his conclusions, and he discussed the issue in more detail, as you know, earlier in his judgment at paragraphs 97 through to 101. And you see him in my submission in those paragraphs plainly applying the dicta of Lord Mance in VTB. And what he's saying there in those paragraphs is making some key points that are relevant to the evaluation as to why this is a key factor, and I submit he's plainly right. He rightly takes into account that these are novel legal claims, and there's no dispute about that. And the judge recorded the fact that there was no dispute at paragraph 18 of the judgment. And secondly, that the Malaysian courts have adopted different approaches to the law in key relevant areas, unjust enrichment and caparo. And indeed, he refers to the fact that there was disagreement between the experts as to whether the court would simply apply hoc parvi and vedanta to the duty question, or whether it would apply caparo. And I think Dato Malik and Tun Arifin considered the court would apply caparo, and Tun Malingen considered that it would simply apply hoc parvi and vedanta. But they all agreed that the principle of parent company liability, as explored in vedanta and parvi, had never been before the Malaysian courts, and that it would therefore be a novel inquiry. Tun Arifin, in his report, also referred to the fact that the Malaysian Federal Court has questioned whether to depart from Murphy. So what the judge was rightly, and he's not really criticised for this, is doing two things, or three things. He's saying these are important issues in this case. These are novel areas. There are material differences. And we can't just assume that the Malaysian Federal Court will adopt the same approach as the English court, not least because we've also seen that it regards as persuasive perhaps to a greater degree than this court does, Commonwealth decisions from countries such as India, Singapore, Australia, and so on. So in doing that, he's alleged to have somehow misunderstood the fact that English judges are quite capable of deciding issues, competing issues of foreign law. And he's not. He's simply applying what Lord Mann says. And when he then uses the phrase policy in 122, he's simply reflecting the fact that there are good policy reasons, one could use different words, for allowing local judges to determine novel points of law of substantial, significant importance to the people of Malaysia.
Well, and it's saying good reasons for allowing local judges to decide their own law.
Yes.
And he's not saying, I am applying, deciding the Spiliada question according to policy.
Yeah. And
it's a very short point.
It's a short point.
And especially good reasons if they're novel points.
And particularly
such
they're
as
novel.
Whether you're extending duties of care.
And you've seen Lord Hope and Lord Bingham are talking about public interest.
Yeah, but
and
it's
national
different.
interest.
They're talking about something completely different.
If you want to, the footnote references for the points that I've made are given at footnotes 13 and 14 of my skeleton, which will take the court to the various differences and expert evidence in relation to novelty and so on. It's worth, I appreciate this is less controversial in some points, but it's worth just noting what Lord Justice Sales said in Unilever in the Court of Appeal. That's Supplementary Authorities, tab 1, page 4, paragraph 5. In that case, the Court of Appeal held that it was agreed that English law and Kenyan law were, for all practical purposes, the same. And in that case, the Court of Appeal held that due to lack of proximity, there was no duty of care arguably owed by the English anchor defendant. So they dismissed the jurisdiction application on that ground. But he said, we're not going to deal with questions of fair justice and reasonableness or foreseeability in case those issues come before the Kenyan court. And you'll see at paragraph 5, he says, if there is to be a trial, it will have to take place in Kenya against UTKL and against Unilever, if they're able to join them. In those circumstances, it is far better that we leave issues of foreseeability and what is fair, just and reasonable in terms of imposition of duties of care regarding events in Kenya in 2007 to the Kenyan courts, which are obviously more familiar with Kenyan society than we are, rather than trying to express opinions about them ourselves. The Kenyan courts will also be better placed than we are to rule upon the effect of the Kenyan Occupiers Liability Act, on which the appellants seek to rely in framing their case in tort against UTKL. Accordingly, we express no opinion in relation to the judge's reasoning on those issues. In my submission, that's the same point. So that is ground 1C, applicable law. Then we come to the defamation proceedings. We dealt with the new position in our second supplementary note dated the 23rd of October at page 336 of the core bundle. The issues which arise, as I understand it now, and I'm not sure this is an issue, is whether we're required to make an application as issue 1. I'm not sure whether that point has been taken against us. Just to be clear,
I had understood it wasn't being taken against
yes.
you, and Ms. Kinsler's not.
So
we can take that.
Well, we can take it, just so that there's no discourtesy intended. The reason I assumed it wasn't was in view of what Lady Justice Andrews said about the parties cooperating and adopting a sensible approach in circumstances where the fact of discontinuance was agreed. So there's that point.
Well, I'm just wondering, at the first stage, we're reviewing what the judge decided on the basis of the facts as they stood before him. Where does the discontinuance come in?
Well, that's
the structure of the reasoning.
That's the second question. Yeah. What is the relevance of it now? And that ship, in my respectful submission, has, as it were, sailed, because the claimants have already made an application to your lordship to refer to the defence in the defamation proceedings. That application was granted, and both your lordship and Lady Justice Andrews said we must plainly have regard to, I'm summarising, but we must plainly have regard to developments in the defamation proceedings. So the claimants have already, as it were, succeeded in demonstrating that the court should have regard to developments in the defamation proceedings. And
well, I'm not sure. I thought I was deciding that. I thought I was saying it was capable of having a bearing, depending on how one viewed the significance of the developments. But anyway,
well,
see your point.
I think all I'm seeking to say is that updating the court in relation to the defamation proceedings is, as it were, in play. Both the court has said that it should be updated. It has been updated because it's agreed that the court should know about the defence and the court should know about the discontinuance.
But that may be because if the right approach is stage one, look at the position as it was before the judge. Did he make an error of principle? Which means that this court is entitled to interfere. If no, end of point. You look at the material as it was then. But if the answer is yes on the material before him, then stage two is this court exercises its discretion afresh. And I think there's no pushback to your submission that for those purposes we look at the position if we get there, as is now, including the fact that there's been a discontinuance. That I think was how Kinsler was putting it.
I mean, my position is that the ground of appeal has gone. The ground of appeal was that the judge erred in finding that joint management was unlikely.
Yes.
That is now academic.
Is it? Isn't it relevant to the question as to whether we exercise our own discretion?
Well, my submission is that the court should take into account the reality of where we are. And if, given that the court has already allowed in the defence and it's already now accepted that the court should be updated, this ground of appeal is no longer live.
No, but if it affected the judge's application of the test as a matter of law, he applied the wrong test because he got the wrong approach, then it does affect the question of whether, to put it my way, the screwdriver has got into the judgment or not. Because if he was right in what he said on the circumstances then of course we don't interfere with the discretion he exercised. But if he was wrong on a question of law, we do. We can.
Well, then I would submit on that assumption it goes nowhere, because even if he was wrong, he's in fact proved to be right, because there can be no joint management.
Well, that's a question for the second stage, my lord's second stage. So, I'm sorry, two stages is rather complicated because it makes it sound as if we're talking about the second stage. It's really hard.
Well,
the first stage is, was the judge wrong in law? If he was wrong in law, some other way that allows interference, then we can, in theory, exercise the discretion afresh. And at that point, you're absolutely right. We take into account the circumstances now, including discontinuance.
But the exercise of discretion afresh, if it takes place, is across the board. Yeah. It's not simply exercising our discretion in relation to that particular aspect of the case.
That is why I'm seeking to differ slightly from my Lord's analysis in saying my submission is that in view of the way this matter has progressed, namely with the claimants seeking to put in further evidence as to prove the judge was wrong, in effect, namely the defence, and the court having ruled that defence should be admitted, it is now the decision of the court that the court should take into account the updated position in the defamation proceedings. And that must follow because it's allowed the claimants to put in the defence. And in situation, the reason I differ from the analysis is that the outcome is that given on doing that, one finds that the defamation proceedings are no longer extant, they've been discontinued, it follows that irrespective of whether the court decides to re-exercise its discretion, that ground has gone. So it will be open to the court to say that ground is no longer live, and therefore we look at stage one through the judge's lens, having regard to his judgment ignoring that ground.
Because you say what the court has said in relation to the discontinuance being in the arena was a decision by the court that it wasn't only to be in the arena if we got to what I'm calling stage two.
Absolutely.
Why would that be the interpretation you put upon it?
Well, because
the court has said the court needs to know about this, and if there is a reason why the court might need to know about it, i.e. if you get to my stage two, why is that inconsistent with the analysis I've been putting to you?
Then we have to look at Lord Justice Warby's actual decision, which I see my Lord is
I
actually
was
doing.
looking at. But my recollection was that this wasn't controversial by the time it got to.
Well, this is the difficulty. But once it's possibly more.
I think your argument has to be that the past was sold by Lady Justice Andrews, if I can pass the buck.
Lady Justice Andrews couldn't have been clearer in saying that the parties that this was. It was plainly in the interests of justice that the court was updated in relation to.
Yes, but my point to you is
that she
was right about that, and with respect, so was my Lord Justice Warby, because it was potentially relevant to what I've been describing as stage two. Whereas your argument, as I understand it, is no, that must necessarily have been on the basis that it took ground 1D out.
Well.
Stage one, and I'm afraid I just don't understand that at the moment.
Well, I accept your lordship's position as my fallback, but my primary submission is, and I appreciate that's not exactly how it was phrased by Lord Justice Warby or Lady Justice Andrews, but in my submission, in fairness, the net effect of it was that the defamation proceedings were in play at the appeal.
I think we've got points, but I, for my part, just to put it to you finally, really, I don't see how you can deal with an appeal de-gutting a part of it. I don't see how we can look at a decision made by the judge and say, was it wrong, but we must now ignore one part of it. I just don't see how you can do that. The decision was a rounded decision, taking into account a number of factors. Was it right in law or wrong in law? Must include the question, was the bit about inconsistent judgments right in law or wrong in law? But it's a point for you if you want to answer.
Yes. Well, you have my submission that I submit the relevance is that the ground goes.
Yeah.
In those circumstances, in the light of the points that I've made.
So you say the ground goes. Okay.
But if I'm wrong about that, I'll make submissions in a moment on why the judge was right. We submit, but the claimants, to some extent, seem to be accepting that the ground stays, but on a narrow basis, namely what they call the Cambridgeshire factor. Their position seems to be we allow it in, but it is now relevant to a fallback argument of the Cambridgeshire factor. So I better just deal with that, because I say two things about that. One, they shouldn't be permitted to raise the Cambridgeshire factor. They could have raised it below, and there would have been evidence about it, and there would have been evidence about it in this court. So it's inappropriate to raise it. And thirdly, I say they shouldn't be entitled to raise it because it's a thoroughly bad point. This is not a Cambridgeshire factor situation, as I'm sure your lordships know. It's not a case where there's a significant build-up of expertise and learning in another substantially similar case by the same lawyers, such that it can be said, and I'm using the words of Lord Gough in Spiliada here, that the case remaining in this jurisdiction would contribute to the efficiency, expedition and economy and assist the court to reach a just solution. And that's Lord Gough at Spiliada, Authorities 1, page 32 at B. And I don't think it's necessary to turn up Spiliada, but if I could just, it's E to B of pages 31 to 32 of the Authorities bundle. And one just sees what the factor, the genesis of the factor was. In that case, as Lord Gough says, I believe that anyone who's been involved as counsel in very heavy litigation with a number of experts on both sides and difficult scientific questions involved is like how much information and knowledge has to be and is absorbed not only by the lawyers but by the whole team, including both lawyers and experts, as they learn about the interrelation of law, fact and scientific knowledge. In that case, but the solicitors and counsel on both sides were the same, and the case had already, the Cambridgeshire case, had already been before Mr. Justice Staunton for 4 weeks, when there was a further application to set aside. They may have faced some questions from my Lord, the Master of the Rolls, on what they were doing. It does seem rather surprising.
Yes.
But at the end of that section, Lord Gough said, having experienced teams of lawyers and experts available on both sides who'd prepared for and fought a substantial part of the Cambridgeshire action for Cancilex, among others, on the one side and the relevant owners on the other, would contribute to the efficiency, expedition and economy, both to assisting the court to reach a just solution and promoting possibility of settlement in the present case. And then he revisited the Cambridgeshire factor in aero speciale, and again, I don't think it's necessary to turn it up, but aero speciale is at divider 2 of the Authorities, and the relevant section where he's dealing with Cambridgeshire factor is at page 62, and he just underlines the fact that armies of lawyers and experts were engaged. That's letter A of page 62. An enormous amount of preparatory work undertaken, and so on. It was in the form of a test case. It's scarcely surprising that the judge regarded the build-up of expertise and understanding among teams in England as being relevant, and so on.
You have no army here, then? I'm just looking at the left-hand side of the court.
There has been no remotely comparable.
Only a small one.
different
One man's army.
brigade,
I mean, it's obviously a different situation. You haven't had 4 weeks. You haven't had the pleasure of 4 weeks in front of Mr. Justice Staunton.
So,
something I remember.
Yes, I mean, there are differences. Just to name one or two of them, the defamation proceedings were conducted by defamation counsel and solicitors, different defamation counsel on both sides.
Well, I wonder how strong a point that is. Obviously, we're not entitled to intrude on questions of privilege, but if for the purpose of the defamation proceedings there was a good deal of investigation into the underlying allegations, for example, speaking for myself, I would find it surprising if that hadn't been shared with the lawyers acting in these proceedings.
But the mere fact that you may have shared information, and it's obviously a privileged matter, but assume your lordship's premise, in my submission, that's nowhere near a Cambridgeshire factor.
No, I quite understand. It's not the same as the Cambridgeshire, but the fact that there are different legal representatives may not be such a bright line distinction, though there's certainly a distinction of degree.
I would respectfully submit that it is a black line distinction, particularly in cases of this type, because it's not unusual, as your lordship knows, in jurisdiction disputes for defendants to take no real issue merits points, perhaps arguing that there's no duty of care owed to the anchor defendant, or no arguable cause of action as against the foreign defendant. And in those circumstances, the English lawyers will obtain a huge amount of information about the underlying merits of the case. And it's never been suggested in those situations that that's some sort of quasi-Cambridgeshire factor.
No, that's a different point. You've got a separate point, which I entirely understand, and speaking myself, I'm sympathetic to. But any expertise built up simply as a result of the fact that you have been sued here and are mounting these applications can't of itself be relied on as a Cambridgeshire factor.
Yeah.
That would be bootstraps.
Or the internal lawyers, yeah.
Yeah, I understand that.
Yes.
But we're on your slightly separate point, which is the relevance of information gathered and expertise gathered as a result of the defamation proceedings. And you were, I think, making the point, well, you can ignore those because those were different lawyers. And it was only against that I was suggesting that may not be a complete answer, although I do, of course, understand that it's not remotely comparable to the
Yes, well,
situation in the Cambridgeshire.
And there were proceedings you chose to bring and pursue quite vigorously. What point?
Well, my lord, we have no choice but to bring those proceedings in this jurisdiction.
I didn't say in this jurisdiction. I said you chose to bring them, pursue them vigorously, and then to discontinue them. That's all before us now.
But I make
at
the
a
point
time that it maybe seems coincidental. In order. I mean, you know, we're not born under a gooseberry bush, if I can put it this way,
well,
Mr. Gibson.
my lord, this is the difficulty. Without going into privileged matters, you'll appreciate there could be any number of factors.
It could be.
And always are in these situations.
So you say we should ignore all that?
Yes.
Okay.
So I make the point, subject to my Lord Justice Popplewell's qualification, nuance, that the parties are different and that's a relevant factor. The causes of action and the nature of the proceedings are different. The build-up of any knowledge or vicarious learning is simply not of sufficient weight, or couldn't be, having regard to how far the defamation proceedings had progressed, to bring yourself within Cambridgeshire factor, which, as Lord Gough made clear when the point was first raised in Spiliada, is such that it can reasonably be said that it's in the interests of justice, because it will assist the court, and there are reasons of efficiency and economy. And we're just nowhere near that territory. And indeed, it's quite interesting, and I actually rely on the cases that the claimants advanced relating to this factor. One moment, please. I mean, one looks at Samsung Electronics, we needn't go to it. But in that case, the parties had been involved in litigation, that's Authorities, Volume 3, Divider 29 in England, for over a decade. Both firms of solicitors acting in the claim had represented their client litigation going back many years concerning this.
My lord has already said it's not a full-blown 10-year litigation type thing, but it's still something.
Well, that's my only respectful degree of difference. I would say it's nothing.
You say it's nothing. Yep.
So, the judge's conclusions in relation to this, if you're against me in relation to the way I approach it, perhaps I could just briefly deal with why I say he was right, if that assists.
Which paragraph?
I'm sorry, my lord.
Which paragraph of his judgment?
Paragraph 120.
120, yes.
So at 120, he says, it seems, this is the challenge, it's the second sentence, where he says, it seems to me unlikely that the defamation case and the claimant's case will be case managed together, or even with a real eye on one another. The parties are not the same in the two actions. The broadcaster may have little interest aligning their defence to the prosecution of the claim by the claimants. I acknowledge there's a possibility that the stars will be aligned, so that the findings of fact will be the same in both claims in England, but that outcome is most unlikely. So he then takes it into account as a factor, and he says at the end of paragraph 121,
I find that odd, actually, Mr. Gibson, that he says, I find it that it's unlikely that the findings of fact will be the same. I mean, as to a particular fact, I would hope that the findings of fact would be the same if the same fact arose in both cases, wouldn't you?
Well,
What's he mean by that?
Well, I think what he means is there's a risk of inconsistent findings because it would be most unlikely that they'd be heard and case managed together, and therefore might not be the same evidence, and so on and so forth. Is that the point?
That's how I interpreted it.
Yes, okay. Well, slightly strange formulation, I think.
But the point that's put against you is that he's simply wrong in saying that that would be most unlikely as a matter of case management.
This is why it's a slightly academic point, because we know what's happened, but leaving that aside, I've been down that road.
We don't know what's happened in terms of case management because there was never an opportunity to conduct it.
No. But my lord, in my submission, this is a question of discretion again, and the question is he plainly wrong on the basis of what was before him? And at the time before him, when he said that the parties are not the same and Channel 4 may have little interest in aligning from a case management point of view, it's important to have in mind that there was no evidence from Channel 4 about case management of the defamation proceedings before him. There was no suggestion from them that this is what they would be seeking. He's right, we submit, or was right. The parties are not the same. The defamation proceedings have been brought by the English Dyson entities, claimants as against the broadcasters. These proceedings, as you know, are brought by 24 individuals against English Dyson Defendants and Dyson Malaysia.
Can I just pause you there? I mean, the argument in your skeleton argument is that the judge was entitled to reach these conclusions on the basis of his experience, not on the basis of the lack of evidence from Channel 4. And I was wondering what experience, his experience seems to be rather different from mine. I was wondering what experience he was entitled to draw on.
Well,
not what he personally knew.
Well, no,
But how could he arrive at this positive conclusion that it was unlikely, rather than saying there's no evidence about it?
Well, he was entitled to draw on his experience, and namely as a judge or a deputy judge, and as a barrister with experience of situations in which cases are jointly case managed, and have regard to the type of difficulties and problems that joint case management of this case would bring. So I think he's clearly drawing on his practice experience. And that, in my submission, was a perfectly reasonable thing to do.
Except that you're now talking to somebody with the most unrivaled experience in the building of case managing.
I mean, let me put to you what I would say. Channel 4. One could look at the reported cases. Faced with a situation where an extremely well-resourced company like Dyson, or group like Dyson, was going to litigate these issues in another piece of litigation, would be most unlikely to say, no, stand aside, we'll do it, at our expense. The most probable wish for a defendant in Channel 4's position would be to have it all litigated out by someone else, at someone else's expense, sitting on the sidelines, doing their best to ensure that the findings of fact will be binding as against them, or anticipating that they would say it would be an abuse for Dyson to contest any adverse findings in a separate libel action against them later. But this sort of thing does happen quite often, and typically the less well-resourced party seeks to stay out of things and stand on the sidelines and see what happens. Why wouldn't that be most likely, as someone experienced in litigation where there are overlapping issues?
Because standing back, my lord, in my submission, the court would have regard to the fairness of that course of action on all of the parties. And on your hypothesis, Channel 4 may or may not be seeking it, but the court has to stand back and look at the interests of justice, the interests of all of the parties. And the question that one's entitled to pose in my submission is, what type of inquiry is one talking about? If this just looking at the Limbu proceedings, it's a group action. You would have a group litigation order made in respect of these proceedings, generic pleadings, schedules of information served by the claimants, identification of test cases, and you would have all of the a small number of test cases tried in order to bind the other claimants in the group. The nature of the factual inquiry would obviously have regard to the causes of action of unjust enrichment, joint tortfeasorship and duty of care, the burdens in respect of those causes of action, and the particular allegations made in that context as to conditions in Malaysia. You would also have, on this hypothesis, at a J, a completely different party present, defending Part 20 proceedings. So you immediately have a completely different situation than it would prevail in the libel proceedings. And you, in the group litigation proceedings, you may decide that you wish to take limitation, for example, as a preliminary issue. So what's being proposed here is a direction for a hearing that would never, in my submission, in my experience, be ordered by a judge in charge of the group proceedings. You would never order a freestanding factual inquiry, because that is what is effectively being said.
But why not? If that would be an efficient way of dealing with overlapping issues in two sets of proceedings, why not? I mean, group litigation requires intensive case management, and there are certain ways which are traditionally of doing it. Test cases, for example. But test cases themselves indicate you're not finally deciding all the issues. You're trying to deal with it. Why shouldn't test cases be regarded as a good idea for the defamation proceedings? Strictly speaking, you could say, well, if they establish the truth of the allegations for those four, it may not be determinative, but in practice it probably will be.
Well, the defamation proceedings involve a different, and I say this with some caution, but as I understand it, the defamation proceedings would involve a different question. The factual inquiry would be different. The factual inquiry in the Limbu proceedings would be whether the allegations were established on the balanced probabilities, the burden being on the respective party. In the defamation proceedings, there's a question of whether, having regard to the ordinary and natural meaning, there are reasonable grounds to suspect that the Dyson UK companies were responsible for the alleged abuse and exploitation of workers. So the nature of the question being asked is completely different in the defamation proceedings.
Well, it's not completely. Typically in defamation proceedings, there are three levels of allegation. One is that it's true, they're guilty.
Yes.
Two is there are reasonable grounds to suspect they're guilty. And three is there are reasonable grounds to inquire into whether they're guilty. A defendant who establishes the truth of the allegation is in a very good position if the meaning of the words is that it's reasonably to be suspected. So if the issue of whether these allegations are true about what happened is tried as a question of fact, then Channel 4 would inevitably succeed on their truth defence, because it's a stronger allegation than they have to prove to in these hypothetical libel proceedings that are not going on. But it's a stronger allegation, and they would have to be proved to be true.
But I mean, we're speculating. But why would they want to be involved in proceedings with?
No, I'm not suggesting they would. What I put to you was a solution that they would prefer would be to see the issue of the truth of those allegations tried without necessarily being involved themselves, and then say, well, it's been proved or it hasn't been proved, and we'll proceed accordingly.
Well, I mean, one of the positions I was speculating about was them, as it were, sitting in the sidelines with their different questions, popping in and out, and then in my submission that is unfair to the and lengthens and increases the cost burden of the proceedings.
I'm not sure that's what my lord was suggesting. It's not that they would be raising their different questions.
They're just waiting.
It would be very helpful for them to have a finding of truth, and if provided they agree to be bound by the result, they could sit and watch or possibly participate to the extent that they needed to. But then the question would be determined. Well,
then their action. I mean, is that one questions efficient and sensible case management in circumstances where their action, where they have possibly easier routes to demonstrating their position, be it public interest or reasonable suspicion, is delayed while the group action which is embarking on a very different, I would submit, and I made my point on that, factual inquiry, progresses through preliminary issues, lead cases, appeals or whatever it might be, and also findings in relation to Appa J. Why I respectfully ask is that in the interest of the efficient and just case management of the defamation
Well,
procedure?
I don't want to prolong this discussion unnecessarily, but I'm just looking at the other side of it. Suppose that Dyson went to the court and said, actually, what we need to have is a trial of this libel action while this case is proceeding, so that we can establish, vindicate our reputation of these terrible slurs. There would be a big problem there, having those two cases proceeding, so that there would be a strong incentive to do what one could by way of case management to avoid that situation arising.
Well, it would depend upon the stages that the different proceedings had reached. And in that, I'm not saying it wouldn't be on the table as an option, but I'm simply defending the judge, saying it's unlikely. And these are a number of the factors that would be in play. And at an early stage, I mean, when the matter was before him, the defamation proceedings, there was no defence. There was a suggestion in correspondence, or an indication in correspondence, that the defence of truth would be raised. There was questions, therefore, as to how long the proper meaning hearings would take. It was going through various stages of interlocutory judgments, as you know, and you were involved.
I recall, yes.
So it was all speculation.
Right, well maybe we have gone on about this for long enough now. Are we at 1E?
This is addressed in our skeleton of paragraph 30. I've already really dealt with this. It's in the submissions that I made in relation to the Cambridgeshire factor. In my submission, it's not a significant factor. It's obvious that claims, if they proceed in Malaysia, will be run and handled by Malaysian lawyers. The fact that the worldwide Dyson Group employs English lawyers, some of whom are based in England, who may be involved in the oversight proceedings, is not a weighty factor. And as I was saying earlier, by parity of reason, the fact that English lawyers, whether internal or external, have gained knowledge and understanding of the issues is inevitable in any jurisdiction. So in my submission, this is another of those evaluation points. It's not unreasonable of the judge not to have regarded this as a key factor.
Do you challenge the underlying factual basis for the assertion, which is if the proceedings take place in Malaysia, it will essentially be the English defendants and the English defendants' lawyers who will conduct the proceedings on behalf of D3 as well as D1 and D2?
Well, not conduct the proceedings. I mean, obviously,
that's not meant to encompass that they won't have local lawyers acting, but the defence, essentially, the conduct of the proceedings will have its control in the English defendants and the English lawyers advising the English defendants.
I'm not.
That's the factual premise, I think, for this submission.
Yes, and as I say, the fact that Dyson Group employees, legal employees, are resident in England, and they will inevitably have an involvement in litigation impacting on the Dyson Group, I'm not disputing. I respectfully submit that that is not a weighty factor.
Well, you say that, but the thing that sort of keeps on reoccurring in my mind is I want to put it in a neutral way, but I find it a little bit difficult. The sort of the way the litigation is being played by Dyson here. It is absolutely obvious to people who've been involved in commercial litigation for nearly 50 years how companies like Dyson operate and what will happen if this case goes to Malaysia. Dyson is not going to allow its Malaysian lawyers to run everything, and you've just admitted that, and accept that they'll have involvement of its, no doubt, very trusted English or even other jurisdictional lawyers. But this all looks a little bit of a construct, if I can put it that way, which is where I was before when I asked you why on earth is this application being made when you've got perfectly good lawyers here, everybody's here before the court, they want to litigate here, you are here, and you're going to be involved in litigating in Malaysia if you succeed in what, you know, again, I'm not trying to be controversial, looks like a bit of a device. And I want to give you the fullest opportunity to answer that. I'm not sure in the evidence anything is really said.
Well, it wasn't alleged that it was a device.
Well, it's not an allegation, it's just a feeling.
And the judge didn't find that it was a device, as it wasn't put to him. Had that been a matter of allegation, then it would have been, of course, directly addressed. But, my lord, it's not a device. It is not a construct. You can see the force of the submissions in relation to the stage 1 factors, and I will take you to stage 2 in a moment. Either those factors have force or they don't. But there's no...
It's the commercial litigation over 50 years that, you know, I mean, it's sort of, we're all dancing round a very large elephant sitting in the middle of the court. Why are we here?
Well, my lord, there's, again, I respectfully submit, there is no elephant. We're here.
There's no elephant.
There's no elephant.
Right.
We are here because Dyson has taken a perfectly proper jurisdiction point, and I've explained to you the legitimate reasons for that in relation to having all the parties before the Malaysian court and the reliance on contractual indemnities. And it's not a device, insofar as I can give evidence. It is not a construct. It's obviously, as your lordship will know, based on advice. Dyson takes the point based on legal advice, which I'm not waiving,
well,
as to whether there is a proper case that can be made that this is the wrong jurisdiction in circumstances where Dyson has legitimate interest in this matter, which I've explained, being tried in Malaysia.
Okay, jolly good. Well, I've got your answer. I hope you'll accept that I put it to you in the spirit of wanting you to have the fullest opportunity to explain to the court what might come into the court's head from their own commercial litigation experience.
Well, I can't obviously fathom exactly what might come into what you said, but I would urge your lordship to approach this by reference to the evidence in this case, and there's certainly been no finding or suggestion that
both the law and the evidence in this case, and nothing else.
I'm grateful. Well, my lord, with that, we turn to access to justice.
Right, round 2.
Ground 2. And this is addressed in the judgment at paragraph 124 and following. And I don't mean this in any way rudely or discourteously, but the court has not had a full picture of the court's findings in relation to this below, inevitably, because my learned friends have focused on particular matters. But could I just start by highlighting paragraph 43 and following of the judge's judgment, where he set out the law in relation to stage 2. And again, as before, there's no real criticism, as I understand it, on his on these paragraphs. And he makes what I submit are very important points which have been taken from selection of Supreme Court cases, but the first at 43 is that caution should be applied when considering whether substantial justice can be obtained. And I just respectfully, and forgive me, I hope I'm not labouring these points, but the word is substantial justice. And that's linked to other points that have been made by Lord Gough and others in the cases. And the reason that caution is urged is that it's been observed that there have been judicial warnings of undoubted authority that the English court should not in this context conclude, other than in exceptional cases, that the absence of means of funding, where such means are available in England, will lead to a real risk of the non-availability of substantial justice. And that's linked to Lord Gough's point in Connolly, which is the second one, which is vital to the judge's findings in this case, and explain a number of them, that seeking to take advantage of a financial assistance available here to obtain a Rolls-Royce presentation, updated to a Tesla presentation by the learned judge, as opposed to a more rudimentary presentation appropriate for him, would not be sufficient to justify such a refusal. Third, and more generally, as Lord Briggs warned in Vedanta, the conclusion that a foreign jurisdiction would not provide substantial justice risks offending international comity. Such a finding requires cogent evidence which may properly be subjected to anxious scrutiny. My Lord...
But that's not really the point here, is it? The point is nothing to do with what justice you'd get in Malaysia if you had funding. The point is, will you really get funding, and the nature of the funding?
Well, they're talking, Lord Gough in Connolly is talking about, expressly talking at 44, about financial assistance to obtain a Rolls-Royce presentation.
Well, I find this Rolls-Royce Tesla stuff incredibly unhelpful. This is about justice, and you get justice by going to the court and having a trial and getting a judgment from the judge. And if you can't do that because you haven't got enough money, then you won't get it.
Yes.
Doesn't matter whether it's a mini justice.
Yes.
Powers are not helpful.
What Lord Gough, I think, has in mind is that you can't say, in England, I would have had 3 leading counsel, 2 juniors, and so on, whereas in the foreign forum, I'm entitled to be represented by a solicitor, or I would have the opportunity to conduct disclosure and have £1 million to do it. And those types of arguments. But they were important in this case, as I will show you. He then refers to key authorities, which there's no need to go to, but it's just to give you a heads up in relation to them. Connolly, there was no dispute that the claim could not be tried in Namibia. Luby was asbestos mining and processing by several thousand plaintiffs, and the finding, crucially, was there's no way of funding lawyers and necessary experts. The funding of necessary experts was crucial to proving liability in that case, and that was not an issue in this case, and I'll explain why. In Unilever, CFAs were unlawful in Kenya, and no other means of funding was available, and there was a risk of judicial corruption. And in Vedanta, again, CFAs were unlawful. And you'll have noted that, and one of the points that was taken in relation to one of the issues which I'll turn to, is that Malaysian lawyers shouldn't be expected to enter into unlawful arrangements, just as Mrs. Justice Lang said in Unilever. But the difference in Unilever was that they were unlawful, and that's not the case here on the basis of the judge's findings. So those principles are, in our submission, very important, and they do underpin the response to that key question. Is there a real risk? I've said that is the question posed by Lord Collins and Altamo, that the claimants will not obtain substantial justice in Malaysia, and the burden being on the claimants to demonstrate that is the case. Now, the starting point, which I don't think has been given enough emphasis, at least so far, is the number of findings the judge made which are not the subject of an appeal. They go to the root of those aspects of his judgment which are subject to appeal. And we made it clear that we were taking this point in our skeleton, and there's been no pushback on them, not least because in our submission it's plainly correct. And this, looking at these uncontested findings, also answers a number of my Lord, the Master of the Rolls' questions as to, well, was this point raised? What did the court have in mind? It will become, I hope, more apparent to you exactly what the nature of the detailed inquiry below was when I show you. And we start at paragraph 126. Difficulties in obtaining justice for migrant workers. The claimants devoted a great deal of evidence to the proposition that the claimants would face difficulties obtaining justice in Malaysia because they were migrant workers. And as the judge found, and there's no appeal against this, halfway through 126, there is clear evidence that many migrant workers do obtain access to justice and obtain representation by trained and experienced lawyers, which goes beyond the negotiation stage. He then refers to Chandra, which goes beyond an experienced lawyer who's represented workers and trade unions, supports that conclusion. So he wasn't just relying on Chandra, and we footnoted the relevant evidence in relation to that in our skeleton at paragraph 33. He then further finds there is evidence to suggest that forced labour is a high-profile issue in the country, including the ratification of the International Labour Organization's Forced Labour Convention. The federal constitution stipulates for the right of access to justice, and this is crucial, my lord. And the legal profession is active, skilled, and public-spirited, acting for migrants. In the circumstances, I do not consider that there is a real risk that the claimants will fail to obtain justice merely because they are migrants. So those findings are not challenged. And the references for those are in footnotes 25, 26 and 27 of the skeleton. And it was based not just on the defendant's evidence, which, as you know, comes from former Chief Justice of Malaysia, Tun Lord Arifin, former Court of Appeal Judge, Judge Kwai. We call him Judge Kwai because the judge did. He was also referred to as Dato Mar. Mr. Chandra, a lawyer of considerable experience representing groups of migrants. Mr. Tony Woon, a Malaysian lawyer and former chair of the Malaysian Bar Council Committee on Contingency Fees. And Ms. Chu, a Malaysian lawyer who pulled together in the appendices to her statement examples of reported multi-party migrant cases. So there were reported migrant cases, there were reported multi-party cases, there were reported industrial injury cases. There was ample evidence of lawyers taking cases on CFAs, and we'll come to the findings in relation to that, against large corporations who would be, I'm sure, described as tough work. So that was the first unchallenged finding I wish to draw your attention to. The second one is the claims were complicated and needed suitably qualified advocates. The lawyers who argued labour and migrant cases did not have the expertise necessary to deal with this kind of case, and teaming up was unlikely. So again, there was a great deal of evidence from the claimants' witnesses that a number of the arguments put forward by the defendants were not cogent because a lot of the lawyers involved were focusing on labour and migrant cases and weren't in some way equipped and didn't have the expertise to deal with a case of this broader complexity involving issues of duty of care and unjust enrichment and so on. And you see those views expressed at paragraph 127 and 128, that's Dato Malik, the claimant's witness, and you see further views expressed by Mr. Pereira, who was an NGO, or chief executive of an NGO, and Ms. Glorina Mala Das in 129. Then he expresses the opinions of Dato Mar Wen Kwai, former Judge Kwai. He expressed the view that members of the Malaysian legal professional judiciary are more than capable of handling a claim of this nature if brought to the Malaysian courts. Malaysian lawyers would have sufficient resources in terms of skill, knowledge and manpower to deal with a claim of this nature, including getting the case ready for trial, there are many lawyers who are prepared to argue novel and difficult points of law. There's no challenge to that, and that was, of course, supported by the evidence. He then reflects the fact that Mr. Chandra, who stated there was no shortage of lawyers in Malaysia who were capable of taking a case involving the issues present claim to the highest levels, he then recognises that it's novel and groundbreaking, but along with former Chief Justice Tun Arifin, notes that lawyers who practice in the fields of industrial relations and employment law are generally familiar with the practice and procedure of the higher courts and so on. So in short, this attack on in relation to access to justice and the fact there was a real risk was completely dismissed. And the findings in relation to that, in my judgment, there's no real risk that the claimants could not find suitably qualified advocates to deal with this kind of case. Substantial justice does not require the claimants to receive the service which they doubtlessly would receive if their claims proceeded in England. And then this is crucial because it undermined the cogency of the entirety of the claimants' lawyers' evidence, and this lesser standard does not appear to have been sufficiently appreciated by those lawyers who have cast doubt on the ability of the claimants to find suitably qualified advocates. This undermines the cogency of their evidence. That is not appealed.
But it also doesn't seem to me to have much to do with the argument against you. The argument against you is they can't afford them, and that the idea of your giving an undertaking to pay bits of their costs is conflicted and very unusual. And so it's not a question of whether, I think everybody in this court anyway with experience of Malaysian justice, and I have quite a lot of it, would know that it's a great system. And there are lots of lawyers in Kuala Lumpur, and they're very good. Have every respect in this court for that court. That's not the issue you're facing. The judge, and if the judge said there are plenty of jolly good lawyers who could do this case in Malaysia, well, I'm sure he was right.
Well, those findings and that evidence was not took into account the nature of this case.
No, but you have yet to show me where he said what he said about the lawyer they could get to argue the case for the money they've got and the undertaking that you gave. And that's the bit that's challenged, not all this.
Well, it's the same point, because it said there wasn't evidence, or the judge was wrong to conclude that there were lawyers who would take this
But he
case.
said there was one lawyer.
Well, I challenge that, my lords. That is an interpretation of one part of his judgment. Actually, when you look at Mr. Chandra's evidence and you look at the other findings, he regularly says lawyers such as Mr. Chandra. Right. And it's wrong to say that the judge pinned his findings in relation to the availability of access to justice by suitably resourced lawyers on the basis of Mr. Chandra alone, or on the basis that Mr. Chandra alone would take the case. And my lord, the relevance of this to I'm not dealing with the undertakings, but the relevance of this to your lordship's point about resourcing. Your lordship, I think, is saying to me, well, so what? There are lots of excellent lawyers in Malaysia. The problem is here, would those lawyers take this case with the resourcing needed? And the answer to that, and I'll take you through the findings in a moment, to which these are related findings, is yes, CFAs have been settled practice in Malaysia since 2005. And there was a great deal of evidence, and this is what the evidence went to, that these lawyers who were taking cases against corporations were doing so on the basis that they were acting on a CFA, meeting disbursements. So these are all interrelated findings. And the important point, and this is why I highlight the cogency of the claimant's evidence, is the claimant's witnesses repeatedly said, no, this is not feasible. They took your lordship's point. This is too expensive a case, and they put forward evidence about the expenses involved. But they did that, as the judge found, and it's not appealed, because they failed to take into account the rudimentary presentation phase. And I hasten to add, when I use the phrase rudimentary presentation, they fail to take into account the fact, I can't get around mentioning it, that they were not, it was not necessary for substantial justice to be obtained for there to be a Rolls-Royce service. This is the point that the judge is making here. The claimant's witnesses repeatedly gave evidence that the case would be too expensive for the lawyers because of various factors, which, as the judge rightly found here, failed to take into account the appropriate standard. This is linked to their failure to take into account the case management directions that would be made. I mean, for example, to give you one example, the claimant's lawyers said, this case will be too expensive because you'll need expert evidence in relation to personal injury. And the judge and the Malaysian court would not make a split trial determination. And yet the judge said, well, of course the Malaysian court would make a split trial determination, in which case questions of expert evidence would only be dealt with at stage 2, following an interim costs order. So,
sorry to interrupt, but does disparity of resources have any bearing at all on the Rolls-Royce concept? I can see that at one level, if you're saying can't get substantial justice abroad, it's perfectly sensible to say it's substantial justice. It doesn't have to be a Rolls-Royce service. But what about the position where the other side can afford and will have a Rolls-Royce service? Now, it may be a sort of question of degree, but one might say, well, litigant in person, if there's an issue of expert accounting, can find someone from his local town who does a bit of accounting and put forward a report. But that's not going to lead to substantial justice, is it? If the other side can afford to have a 300-page report from KPMG or so on. Well, so I wonder whether we have to factor in to the point you're making, not just what the claimants could themselves achieve or not achieve, but how that looks compared to the defendants whom they're suing.
Perhaps equality of arms.
Equality of arms, I accept.
Yes.
That of course, that would play into substantial justice. I would accept it must be a feature of substantial justice. But the important point in this case is that the judge, that did play it. There wasn't a point taken, and the judge didn't find that the claimant's lawyers were not very well versed in the law, but nonetheless would do a decent job. His findings were that they would get substantial justice, both in terms of what funding was necessary and having regard to previous examples of lawyers in Malaysia who had represented migrants against large corporations. I think my only qualification to your lordship is I would accept that it could be a relevant factor, but one would have to apply it with caution, because otherwise it would emasculate what Lord Gough said and about the need for substantial justice, because you'd be looking more about who's, the resources of the party on the other side. I mean, many people would say this criticise our own system and say it favours those with greater resources, but you wouldn't say you couldn't get substantial justice in this country because you're up against a large corporation. Because
people might say that.
Well,
we've got more different litigation funding mechanisms here.
Well, this is why it's so key that they have CFAs in
CFAs of a kind in Malaysia.
Well, that's essentially the same. You take the risk on the case and you make your money from the percentage of damages. But anyway, it's important to see these findings in context. And one then goes to the third finding. It's not possible to case manage out complexity. This is page 110. although personal injury cases could easily be divided into liability and quantum, this was not possible for a claim of unjust enrichment. I'll come back to that. A very substantial part of the case would involve unjust enrichment, and an estimate of 6 months for the trial had been given. Then he deals with this, and essentially, and I'll take you to it, he accepts the defendant's case management model, because in order to demonstrate that Malaysian lawyers would be able to fund this litigation, the claimants, the defendant's witnesses, adduced evidence as to what directions the Malaysian court would be most likely to make in order to make the litigation ensure that the issues in the claims were dealt with expeditiously and fairly. And it's important again to underline the extent to which it was contested by the claimant's witnesses that a number of these directions would be made, and I'll come back to that. But in short, in 133, he finds that there would be test cases, there would be a split trial, there would be an order for costs to be paid by the unsuccessful party, and for damages to be assessed, and so on.
But he does accept that the unjust enrichment claim would have to be dealt with at the first stage as part of a liability trial. But he suggests at paragraph 134 that the issues which that would involve would require some evidence and analysis, but it'd be surprising if the time devoted to it was extensive.
Yes.
I have to say, I raised a metaphorical eyebrow at that if the extent of the enrichment of the Dyson companies in this country as a result of the particular products on which these claimants worked wasn't a matter of very substantial complexity and difficulty.
Well, there's no appeal against that finding. It's not attacked as a finding in the skeleton or in the grounds of appeal. And it's also worth mentioning that it was raised by Mr. Hermer on his feet on day 3 of the hearing. So it wasn't a matter that featured in evidence, which is why the judge said in the final sentence of 134 there was no evidence presented to the court to suggest otherwise.
Thank you.
But nonetheless, the judge did take into account, and this is the fourth finding, that there would be very significant disbursements, not least on expert fees, and there would be a need for forensic accounting, and I'll come back to that for the unjust enrichment claim. So the judge still took it into account. But just finally on the uncontested findings, I've dealt with 126, I've dealt with 127, I've dealt with case management. Again, all the subject of contrary evidence. And one was left asking, my lord has repeatedly said that the Malaysian courts operate on essentially the same principles as ours. And that's exactly what Tun Arifin and former Judge Kwai was saying. And that was contested. We were saying the Malaysian court would be aware of equality of arms, the need for equality of arms, would be aware of the need for efficiency and justice in the directions it made. That would lead it to make directions which ensured that there was, so far as possible, equality of arms and expedition and fairness, such as the type of group directions that would be made in accordance with the Malaysian overriding objective along the same lines as ours. And that was again the argument, and this was also another finding that's not contested, that gave rise to many pages of the judgment at paragraphs 87 to 93 about remote hearings. The claimant's witnesses contested that the Malaysian court would make remote hearings, even in circumstances where the evidence was that, and it was not disputed, indeed it was accepted, that a number of the claimants were concerned for their welfare.
I think they do more remote hearings than we do, in fact.
Yes.
At a more senior level.
But that was a matter that was the focus of a great deal of evidence and had to be determined. And this is another of the examples of the case management model that was being put forward by the claimant's witnesses. They said it just won't be possible to have a trial because you can't have remote hearings and we need them. So they had a huge argument about that. And then most crucially, they pitched their tent on CFAs. That was the source of a huge amount of evidence, and and you'll see that it's a major source of the judgment. And we deal with this in our skeleton. It's 33D, but it's the judgment, paragraphs 156 to 165. And you see it's item 9. The claimants contended that partial CFAs were unlawful. Now, there's a narrow challenge to this now, but the fundamental finding that they were lawful and settled practice is not challenged. And you can see that the judge took into account at 157, 158 and 159 the counter evidence that CFAs were unlawful. And then he addresses the counter evidence, the evidence of the defendants of Mr. Chandra and former Judge Kwai in 160 and 161. And he underlines the fact in 162 that in arriving at his view, former Judge Kwai had referred to the case of Chai Chi Chin, which had also been upheld in the Court of Appeal. And there were a series of Malaysian first instance and one Court of Appeal case in which the basic fee arrangement was approved. And that started in 2005. And that was also the position taken at 163, you'll see, by the Malaysian Bar Council. So you have a basic fee and a success fee, and then that is a lawful arrangement. And we'll look at it, if we may, briefly when we come to it, as it's part of the challenges, but it's worth just rereading the summary of Tony Woon's evidence. He was the... I'm
sorry to keep interrupting you. The reference to Chai Chi Chin at the beginning of 162, is that the defendant agreeing to, defendant's lawyers agreeing to a contingency fee, or is that plaintiff and defendant the wrong way around?
There was an issue in that, that's the defendant's solicitor, because there was an issue in that case as to whether the agreement was lawful. So there was the question as to whether receipt of a basic fee and the success fee was a lawful arrangement was directly in issue.
Oh, I see. I understand.
Yes. Sorry. And that's been the position since 2005. And then this was crucial evidence which informed the judge's view, but in 164, and informed the views of Judge Kwai, that Tony Woon, who was the chairperson of the Bar Council Ad Hoc Committee on Contingency Fee Rules, stated that the Bar Council had considered the basic fee and success fee model to be lawful, but had proposed to regulate the practice. The retainer that was set in the draft rules was designed to ensure compliance with the case law, so they were giving effect to the case law by saying all you need to do is have a small basic fee of 500 to 1,000 ringgit, depending on whether it's personal injury or non-personal injury. He explained, and this is important, some of the arguments you've heard, that the minimum fee was not set by reference to the value of the case or the work involved. The remuneration of the lawyer would come in the event of success from tax costs as well as the success fee and full recovery of disbursements. He explained that it was often necessary for our lawyers acting on success fee arrangements to fund the disbursements for the clients. He was not aware that the Attorney General's chambers had expressed any concern about lawfulness of success fees. He was not even aware there was any doubt or controversy within the legal profession that these arrangements were other than lawful. So the judge then held that I don't consider there's a real risk that partial contingency fees, sometimes called success fee arrangements, are unlawful. One, and there's no challenge to any of this, it's clear that there's a frequent and regular practice of lawyers taking cases in Malaysia on a partial contingency fee basis. Two, this has received repeated judicial support, including from the Malaysian Court of Appeal in the case of Luar Mansur. Three, it's the view of the Malaysian Bar Council, which has repeatedly made reference to the lawfulness of such fee arrangements. Next, there's been no dissent from this view by the Attorney General. Their concern is a different point. And in my view, he says, I'm not a Malaysian judge, but it seems to me to accord with the wording of the statute. And it's on that basis that he was driven to the conclusion that the views expressed to the contrary by the claimant's witnesses did not withstand anxious scrutiny. So, this is in part goes to my Lord the Master of the Rolls' point. There's no challenge to the fact that it is a frequent and regular practice of lawyers taking cases in Malaysia on the partial contingency fee basis. And he's already held that those lawyers are taking cases on behalf of migrants, and that's not challenged, and that they have the expertise needed to take a case of this type. So we respectfully submit that when one looks at the judgment, 2 points follow. The anxious scrutiny to which the judge subjected all the substantial justice evidence is to a significant degree unchallenged. The findings of the judge which are the subject of appeal, most of which are on analysis very narrow, should be read fairly in the context of his unchallenged findings. And thirdly, third point, this court should be even slower to subject the evidence to a re-evaluation, particularly in circumstances where there is no challenge to the key finding that the entirety of the claimant's evidence from lawyers lacked cogency. And I've shown you that at paragraph 32, because the lawyers who gave evidence for the claimants had not sufficiently appreciated that substantial justice did not require the level of service to which they were attesting. In fact, as I say, it's as much as anything, it's not just about the level of service, such that there could be an equality of arms. It's taking into account the case management directions that the Malaysian court would make to ensure that these claimants did, in accordance with the Malaysian constitution, have access to justice, which any Malaysian judge would be keen to ensure by ensuring that directions designed to promote efficiency and fairness and expedition were made. So, we then turn against that background to the particular challenges, and when one boils them down, apart from the undertaking point, which I appreciate is central to the model, as it were, they're actually quite narrow, and we will respectfully submit don't fairly reflect what the judge found. The first challenge at ground 2A is that the judge was wrong to conclude that there was no real risk that the claimants would be unable to fund the costs and disbursements necessary to pursue their case to trial in Malaysia. My learned friend took you to the disbursements table and was generally a look of surprise because it looked as if it was all there were very low sums involved. That is because the disbursement table takes into account the undertakings is not a profit cost table. It is only a disbursement table. And it calculates the disbursements that would be payable, having regard to the case management model, and is focusing on filing fees and the court costs, because in their opposition to the defendant's proposals, the claimant's witnesses had adduced a lot of evidence about how much it would cost to file witness statements and so on. So that's what informed the disbursements table, but I'll show it to you. But we have to start, briefly if we may, with the case management table, which is at the core supplementary.
I mean, before we get into the weeds of this table,
I won't go too deep.
what if Dyson, by some chance, decided to play hardball in the litigation in Malaysia, and thus necessitating applications to be made of a disparate kind in the course of the litigation, where fees had to be paid, which could not be paid on the undertaking, because, after all, you're the people who know what sort of litigation tactics you may adopt. So what if there were further fees that became payable for goodness knows what? I don't know the Malaysian justice system well enough to know when you pay fees, but I expect you do like we do from time to time. And what if Dyson managed to engineer a situation where these completely impoverished claimants could not get the money and your undertaking didn't cover it? What happens then?
Could I mean, the one answer to that is that, my lord, There is no finding that Dyson would not conduct the litigation in an entirely fair and proper
I
way.
didn't say anything about unfairness. I said hardball is litigation.
Well,
Look, once again, you are talking to people who've undertaken commercial litigation for clients like yours over many, many years. And all I'm saying is that you can be expected as a litigant defending a claim to defend it properly and hard for your clients. Now, I'm asking you what happens when that necessitates fees being paid which are not the subject of an undertaking that has been thought of in advance, and gives them a problem because they have no resources.
well, that is why they would be on, and this is why the evidence, some of which I've taken you to, is so important. Leave aside disbursements for the moment, which would not be a significant factor. Those are the kind of costs. We're talking about profit costs, the time and... I'm sorry.
I'm shaking my head because I'm not sure we are. To give a concrete example, the undertaking covers disbursements on a joint expert report. Suppose, which speaking for myself I would find not unlikely, but there are circumstances in which it would be reasonable to take the expert view privately and under the cloak of privilege in relation to the conduct of the claim. Now, how is that dealt?
I'm sorry, my Lord.
How is that dealt with? It's not within the terms of your undertaking.
Well,
Your
because...
clients would say, we haven't given an undertaking to fund that, and that's tough.
Well, that's why the case management model is so important, because if we get to the position, and I'll come on to unjust enrichment expertise, but the sort of expert evidence that you would need in this case is expert evidence in relation to the personal injuries. That would only be needed after the determination of liability. So we've already got a finding by the judge that the court would make an interim costs order to the claimants. So at that stage, they would be able to afford...
Sorry, you mean after liability?
After liability.
Well, that's, I mean,
But
finding liability in this case is respectfully miles down the road.
Well, I understood that your lordship's point, forgive me, my lord, was in part that what you're leaving out of account, your lordship is putting to me, is the fact that Dyson may fight hard, and that might give rise to a lot of costs for the lawyers taking the case.
They might even be designed to do that.
And they might be designed to. That has been addressed by the judge, because one of the arguments was that Malaysian lawyers would not have the resources and wherewithal and determination and commitment to take on a tough opponent. And the evidence that the judge took into account and evaluated was that Malaysian lawyers working on CFAs were used to dealing with tough corporate opponents and would be able to resource and manage this case.
Okay, where's the bit about the tough corporate defendants?
Could I come to that, my lord?
Yeah.
It's dealt with in the judge's findings. I mean, I can deal with that, and I can come to the evidence later as I was going to. But it's...
I mean, the question, just for the avoidance of doubt, the question I put to you is about funding the consequences of having a tough corporate opponent.
Well, the funding is... There's the disbursements which would not be great because of the undertakings. The undertakings are a separate...
Yes, but not great doesn't help people who have nothing.
Well, the people who need the funding are the lawyers who are on the CFA.
I mean, we're talking about
Yes,
360 ringers.
It's item 6, and it is the subject of an appeal. The prospect of a small band of practitioners being willing, this is paragraph 145, to take the risk was reduced when considering that they would be opposed by defendants without any effective limitation on resources, represented by one of the largest law firms in the world, where aggressive and heavy-handed approach is likely to be taken to defensive proceedings. And the judge addressed that and said, I've no doubt Dyson defendants would prove to be a tough opponent. There's nothing I've seen or heard about which the Dyson defendants have conducted the present proceedings, and from what I've been told about defamation proceedings, to suggest that the Dyson defendants and their legal representatives have in this jurisdiction.
That's not the point. David is suggesting that it's illegal or improper.
Well, he then goes on at 146 and says, the fact that the Dyson defendants will prove to be difficult opponents and have no real limit on the resources available to them is unlikely to make any difference to the willingness of legal practitioners in Malaysia. This is relevant to a point I made earlier, such as Mr. Chandra on his own or with other law firms that he's referred to take the risk of representing the claimants. So there are a number of findings to the effect that Malaysian lawyers are well used, it has been settled practice, and Malaysian lawyers are well used to taking on tough corporate defendants on CFAs. And I appreciate they're taking a financial risk, but that is what solicitors are doing in this jurisdiction when they take on a big case, as Lee Day, for example, often do. So just to show you the case management table, it's at Core Supplementary 12-434. No, it's not. We don't need to dwell on this, but it was thought necessary to put it before the court because, as I've explained, there were so many issues taken about the nature of the directions that would be made by the court. And so it was put before the court in the form of a Scott schedule, and you can see in red the comments of the claimants. I don't ask you to go through it all now, but if you just go, for example, to page 436, our expert said the court can and would, if the parties made an application, order a split trial to determine liability before causation and quantum, not accepted. The court can and would, if the parties agree, order a small number of test cases, is the second one, not accepted, and so on. So in all of the claimant's witnesses' calculations of costs, they were assuming a trial of all cases. They were assuming no split trial, and so on.
I mean, I completely understand all that you were all trying to dig down into the weeds of what would happen. But the truth is, nobody can predict how a piece of litigation will go in a foreign country. The Malaysian courts obviously have exactly the same tools as we have to manage litigation fairly and get it to reach its end in the best and cheapest possible way. But we know here, where we have all those tools at our disposal, that sometimes things happen in litigation, and actually not sometimes, always things happen in litigation, and tactics are advanced to slow it down or speed it up or do whatever things. And so going into all this seems to me to be utterly pointless, because we have no idea. The judge has found they can do all this, and I'm sure they can. That's not the question. The question is, can these people afford to fund that in Malaysia? And the thing that, because of the partial CFA situation and the need to fund some things themselves, it seems to me that they're not dealing with the contingencies. That's the problem, and that's what you've got to address. If of course you can show that they can find, if it is, find the 300 ringgits, if that's the right figure. And I think we're told it's not the right figure, but let's assume it is for the moment.
Nothing turns on.
That's not the problem. The problem is the litigation will go on for months and years, and there'll be all sorts of ups and downs, none of which can be controlled by an undertaking here, and you hold the purse strings because you have given an undertaking to pay for this, and that is really what you've got to address.
That perhaps not very well, but that's what I am seeking to address, because I've shown you the findings from the judge relating to those broad questions. I'm also demonstrating to you, not just by going into the weeds for the sake of it, but rather than just say in a bald way through our evidence, Malaysian lawyers will manage this litigation. I'm showing you the extent to which the witnesses applied their minds to what that evidence actually meant, so that we were coming up with practical solutions to your lordship's problem. You might have said to me, you are saying to me, well, there's lots of evidence the Malaysian lawyers are excellent and public-spirited and so on, but how would they actually have, how can you say that there is, they would be able to resource and take this litigation to trial? And I'm starting that answer by saying, well, first of all, what they said was, we would take the litigation through this particular, using these case management directions. That will reduce the cost. I have to come on and then show how they would still do it.
I mean, the single line in the judgment that you have to deal with, as it seems to me, which although is not is only glancingly related to the question we're discussing at the moment, is in paragraph 147. I also do not consider that there is any conflict of interest here with respect to the question of costs.
Absolutely. That is crucial
And
in the
that
undertaking.
seems to me to be absolutely central
It is. And
to the appeal on stage 2.
Yes. Will you forgive me if I do come to that?
Of course, but I mean, it's helpful to me because it stops me asking all these trivial questions along the way. If you give me your answer to that in 2 sentences before we break, then I can go away and cogitate on it.
There's no conflict of interest because it is in Dyson's interest for the case to proceed in Malaysia. Therefore, it is in their interest to ensure that the undertakings in respect to logistics are complied with.
Therefore,
secondly,
just say that again. Therefore,
it is in their own interest to ensure that undertakings are complied with. Secondly, it is, in my respectful submission, unfair to premise an appraisal of those undertakings on any express or implied assumption that Dyson would not comply with an undertaking that is given to the court.
So to be clear, you say the judge was right to find there was no conflict of interest.
Absolutely, my lord.
And there couldn't be one by these arrangements.
I'm sorry, my lord.
I'm writing down your submission. The judge was right to find that there was no conflict of interest as to costs and that there could not be one under these arrangements. Okay, got it.
And I will return to the undertakings, but in respect of the undertakings which you're concerned with, which concern undertaking to pay the costs of obtaining witness evidence, for example, and remote hearings, there's no conflict because if they comply with their undertaking, it follows that all that needs to happen is for the claimant solicitors in Malaysia to say, we have incurred X, we need X costs in order to set up the remote hearings. And Dyson will have to provide that money.
When they ask, well, wait a moment, you say it's going to cost all this, but we're only obliged to pay you a reasonably necessary amount. So what are you proposing to do? Where are you going to do this? And why do you say it's going to cost that? Then what happens?
Well, in my submission, it's unreasonable to assume that, given that it's as I started by saying, it's in Dyson's interest to make sure that these work. Therefore, it would be counter to that interest to make unnecessary problems.
Well, you're giving us your headline points and you're going to develop them. Speaking for myself, I've understood what the first proposition is, that it's in Dyson's interest that it works, but I don't quite understand why that should be shown. It's presumably in Dyson's interest that the claim should fail.
No, it's in Dyson's interest that the claim proceeds in Malaysia.
No, sorry.
No, it's in Dyson's interest that it doesn't proceed anywhere.
Yes,
but
You get to stay here and then in Malaysia.
But that's if I say so, jumping the gun, my lord. We're postulating the progress of the claim in Malaysia. It's in Dyson's interest that it stays in Malaysia. It's unfair on Dyson to, in my submission, build into the reasoning an inference that Dyson will take a step in relation to the undertaking which undermines them or makes it harder for the claimants, because that could result in the stay, in the claim coming back to England, because Dyson would be in breach of an undertaking.
I mean, once we've said that the proper forum is Malaysia, then it will be dealt with under Malaysian jurisdiction, and if it fails in Malaysia, that's the end of the matter.
Well, there would be a stay here, and if Dyson didn't comply with an undertaking it had given, there would
It's
surely
terribly
be...
complicated. I mean, if that's your sort of argument, that we're going to have to police the proceedings in Malaysia, I would have thought that's another pretty important thing to take into account. Is that what you say? We have to police that?
No, I'm not suggesting it would be necessary to police it, because my primary position is it's wrong to assume that there's a conflict in circumstances where Dyson is seeking to ensure the proceedings go ahead out of its own interests in Malaysia, and to assume, in effect, that Dyson will be unreasonable and undermine those undertakings.
You say it's wrong, just before we rise, for us to assume that Dyson will take all lawful steps to protect its interests and try to defeat this claim.
Of course, I accept it will take lawful steps to try and defeat the claim, but it will also comply with its undertakings to the letter and to the spirit.
Right. Well, the spirit of the undertaking we can discuss at 2 o'clock. Thank you.